Mine as well?
Yep.
Excellent. It's a really good turnout actually for the middle of, well, summer. I have to say, when I touched down on Monday, I was reminded of why I live in Australia now and not the Netherlands. And particularly when you see the weather in Hobart's warmer than the weather here, but we're not here for the weather. It's to see everyone and have a conversation today about sexual and gender-based violence and a trauma-informed approach. So a warm welcome to everyone. Thank you so much for making the effort to come, and everyone online as well. And to my wonderful panel here who have put their hand up and given a couple of hours of their time today, which I've never met any of these incredible women here. So I'm happy to be meeting them for the first time and sharing an esteemed panel to talk about this really important topic. I'll introduce everyone. So to my left here is Neve Hayes, who is with the OTP. She's a legal officer with the Gender and Children's Unit at in the Office of the Prosecutor, and she's been here at the court since 2018. She's got a long and established experience in this field. She was previously seconded to the ICC by UN Women as an expert advisor on gender. From 2012 to 2016, she was the head of the Office for the Institute of International Criminal Investigations and delivered specialist sexual and gender-based violence training for practitioners. So we are in very capable hands here for civil society and law enforcement on 4 different continents. She's worked on sexual and gender-based violence training and best practice projects for the UN Department of Peacekeeping Operations, UN Women, and the UK Foreign and Commonwealth Office, and has published several academic pieces on international criminal law and practice relating to sexual and gender-based crimes. Welcome. Thank you very much, Neve, for joining us today. Then we've got Cecile Lecor, who's from Defence. And I think as the advertising for this particular session said, it's really what we're really trying to do here is get people from all the different organs to talk about this really important issue so that we can, work together and collaborate and understand each other. I think there needs to be more of that. Cecile has worked on various defence teams across international courts for the last 10 years, so since 2013. Some highlights before this court. She's currently on the defence team for Mr. Malcolm, and going to confirmation in August, I think, by the sounds of it. So very busy summer for you, Cecile. She was previously on the defence team of Jean-Pierre Bemba and of Mr. Al-Hassan. She was an associate legal officer at the OPCD in 2021 and a consultant for the IDLO on training judges, registrars and defence lawyers in international criminal law in Rwanda from 2017 to 2021. She's also currently the Vice President for Support Staff and member of the Executive Committee of the ICC Bar Association. It's a busy life. Thank you very much, Cecile, for taking the time today. I'm also very excited to introduce Maria Clara Cavalcanti, who is an associate psychologist and gives us that fantastic perspective of the non-lawyer, which I think we really need. Sometimes we definitely need to go and step outside that zone of and look at it from the psychologist's perspective. So very grateful to have you here. She's with the Victims and Witnesses section, which was the Victims and Witnesses unit when I left, and now it's the section, so it sounds like you've grown. She graduated as a clinical psychologist and has a master's degree in intercultural psychology. She's been with the court for 5 years and has spent her career to date working with vulnerable populations in social, healthcare and legal settings. And I'll introduce myself as well. I'm a barrister from Tasmania, Australia, but I did spend 9 years at the court working for the Office of the Prosecutor, first as in the legal advisory section, and then for a couple of trial teams. My former boss is in the audience, so I better be on my toes, Anton Steinberg. But now my practice, since I came back to Australia, I do a mixture of civil and criminal matters, and I'm also the ICC Bar Association focal point on sexual and gender-based violence. I work with victims on a daily basis of sexual abuse. We recently in Australia had a Royal Commission which into institutional abuse in schools and churches and foster care and state And one of the things that happened there was a lift of the statute of limitations. So all these people can now sue and get good payments for the harm that they suffered. So my daily work is talking to people who many years ago were horrifically raped and sexually abused, a lot of boys but girls as well in these institutional settings. So the sad thing about that is I didn't ever think that I'd use the skills I'd learned at the ICC in a domestic setting in what we're supposed to be a model country in Australia, but we do. So it also continues the work and has informed the topic of this conversation about being trauma-informed when we talk to those witnesses and victims of sexual violence. So the format today is we're all going to speak for 20 minutes, 30 minutes. I'll probably speak a little bit less because I think these ladies have more to say than I do about a lot of these a lot of the issues we want to discuss. And then we're going to open it up to the floor for questions and also from online, so you can send questions through. We want it to be a really open discourse, informal, high level, in that we're not talking about intricacies of any cases that anybody's working on, because we're all from different sides of the table, but a really open discourse about ideas on how we can all be more trauma informed when we're talking to witnesses and victims of sexual violence. So that's the sort of approach we're trying to take. As having worn the prosecution hat, and this is sort of going back to the real importance of all of these discussions, that I wore the prosecution hat for nearly a decade here, and now being at the bar and counsel at the bar, I get to wear all sorts of hats. But what has become abundantly clear is that we're all responsible to ensure that witnesses and victims of sexual and gender-based violence aren't re-traumatised. And that's the court collectively, but also us as individuals. We do have a responsibility towards these people, that they're informed they're approached in a trauma-informed manner, but without compromising the integrity of the ICC's system of justice. I mean, Article 68 of the Rome Statute is clear about this. It says that the court shall take appropriate measures to protect the safety, physical and psychological well-being, dignity and privacy of victims and witnesses, and expressly points out that it will have particular regard to crimes involving sexual and gender-based violence. At the same time, the statutory rights of the accused need to be maintained, as do the fair and impartial trial rights. But this can be done in a manner which prevents the re-traumatisation of witnesses. The best way to accomplish that, in my humble opinion, is in the spirit of cooperation across the organs of the court. Everyone has a role to play. Prosecutors prove their case beyond a reasonable doubt. At trial, defence represent clients and defend cases to the very best of their ability. Counsel for victims represent victims in the case, and the honourable judges and our colleagues in chambers ensure that proceedings are conducted in compliance with the legal instruments governing the court. But no matter which side of the bar table we sit, or which side of the bench we sit, no one needs to set out to re-traumatise victims of sexual and gender-based violence. And that's something that we as counsel really need to keep at the front of our minds. It's still possible to test the evidence of a victim or witness of sexual and gender-based violence in a trauma-informed manner. Although doing so, we may need to deviate from methods of cross-examination, which may be termed as traditional methods of cross-examination. One of the benefits of this fused civil and common law system, which I miss, I have to say, in the common law system, it's in my view, a far more practical system to have. Well, juries are very difficult to deal with, but the ICC has this system, which means that counsel's hands aren't tied in the way that they generally are at common law. Hearsay is admissible. For example, there's other forms of evidence and questioning. There's a more relaxed approach to leading questions. in Australia, and I'm not going to Australiafy this presentation at all, but we do have now in place more litigant rules when it comes to victims of sexual and gender-based violence. And they are there particularly for the prosecution and for the state, but across the board, council should really pay attention to these, and they are meant to minimise the potential re-traumatisation of victims of sexual abuse. My fellow panellists will be speaking about the technicalities of trauma and the techniques on how to conduct interviews and examinations in a trauma-informed manner. And we have the expertise of the psychologist here who will give that understanding and perspective that isn't purely from the lawyer's perspective, and for that we're truly grateful. A person, just from not from a psychologist's perspective, but certainly from my own experiences, I've seen that a person who suffered trauma from sexual violence will often store information in a way that's very different to those who haven't. They'll react to certain types of questions in a manner that's different to people who don't suffer from the effects of trauma. And this needs to be factored in when we're speaking to witnesses and when we're questioning them in chief and in cross. Building trust and rapport, being thoroughly versed in cultural sensitivities, and we have experts on the panel about that today, which I'm really looking forward to hearing about. Creating physical and emotional safe environments for sexual and gender-based violence victims to tell their stories, including open-ended questioning, which allows the narrative to flow without interruptions. Expressions of genuine empathy and patience and acknowledgement that narratives can flow in an order which may not sometimes seem logical. These are all integral to maintaining a trauma-informed approach. I mean, a victim of sexual violence may at times have difficulty remembering details, and it's not important to immediately infer deception from that or issues relating to credibility. In some cases, they may not be telling the truth, we still also need to keep that in mind, because that is balancing, the defence, the work that the defence does. But also, in some cases, victims may be withholding information, including details of sexual assaults that to them seem shameful or humiliating. And this is particularly prevalent in some of the cultures that, we have before the ICC, where speaking about sexual violence or sex at all is completely taboo, and often silence prevails rather than speaking about sexual and gender-based violence. And that's a huge challenge. I know that is here at the court, from both sides of the coin. So as such, we need to put protections and mechanisms in place to assist in ensuring that the evidence elicited and relied on is the best evidence possible from the defence and from the prosecution. We need to make sure that we get it right. Mechanisms such as agreed facts, and Cecile and I were having a chat about this morning, prior to trial are particularly useful. Even if it's just about a small portion, defining what a word may mean in a particular culture, so it doesn't need to be repeated and re-traumatised, all the while still needing to get out the evidence of whether or not sexual violence or sexual crimes occurred. Examination of victims of sexual violence by counsel who have requisite experience in dealing with sexual and gender-based violence, in my view, is key. It can't be a training ground for new counsel. We need to have people guided. I understand that everyone needs to get their experience. We all have to, but there needs to be proper guidance on both, again, on victims, defence and prosecution side of the table to understand that. And often the assistance of experts can help in that regard. And I know that that's been the case in some of the cases we've had at the ICC, where experts have guided through the court through, including the chambers, of how sexual and gender-based violence witnesses give evidence. I think what I'll do now is I'll throw to you, Neve, if you'd like to go next, if that's okay with you. Yeah, and I'll let you take the floor, and we'll go through each of us, and then we may have a little break, and then open up for questions. All right, thank you, Neve.
Yeah, I absolutely agree with everything you've said there, Regina. I think that there are a lot of well-intentioned but inadvertently unhelpful stereotypes that attach to sexual and gender-based crimes in particular and victims of those crimes. And the assumption being that they become one homogeneous block as soon as they experience a certain form of violence, which as soon as you hear it said out loud in those terms is patently ridiculous. That everyone is an individual and has different personalities and different strengths and weaknesses and vulnerabilities and areas of resilience before they experience those types of crimes. So then the impact of those crimes on them will vary dramatically from person to person. Even multiple victims or witnesses that are called in relation to the same incident, who experience the same types of crimes within the same culture or society, can have dramatically different responses to it. And I think the crucial thing to remember is that for some victims, it is absolutely beyond question that their experience of sexual violence in particular has an impact on them that is different to other crimes. And part of the reason for that is that there is a stigma and a shame and a taboo and a sense that the way in which they are seen by their family or community will be irrevocably changed if that information comes to light. And that manifests itself in different ways for female victims and male victims and LGBTQI victims. But there's as much as it can be true, and it frequently is true, that it is a uniquely traumatic event. Again, you always have to remember that you're dealing with individuals. And there may be, and there have been in many of our cases, people who are called to testify who have been a victim and a witness of sexual crimes, gender-based crimes, and completely unrelated forms of violence. The thing that has been most traumatic for them as a person may not be the sexual violence. It may be something that they witnessed that affected a family member. It may be the long-term impact of having been displaced by those crimes and losing their home and their belongings. So the very remedial step one introduction to a trauma-informed approach is to just always prepare yourself by thinking about how things could potentially manifest for that person, but to not have any preconceptions and to basically engage with an individual as an individual and to take your cue from them. And also, Regina is completely right that we do have an obligation to make every effort that we can to avoid re-traumatizing someone. But to me, a trauma-informed approach goes beyond just avoiding re-traumatization. Do no harm is like the basement level. And sometimes we don't make it out of the basement. Like we don't always manage to do that. And again, that may be because of the way in which we conduct ourselves, no matter which party it is, or it may be just the experience of interacting with the judicial mechanism and the various implications and triggers that come along with that for a specific person or a victim or a witness. Ideally, a trauma-informed approach means educating yourself well in advance as part of your planning and preparation for everything, for the way in which you approach individuals, for who you use as an intermediary, for how you brief your interpreter, for the way you set up the meeting room when you engage with them. And sometimes the advice and the things that you may plan for and expect, you have to adapt to very quickly in the moment, because it's very common to see people saying, well, given the stigma and given the very personal nature of discussing something like that, make absolutely sure that you have privacy, that no one can see you, that no one can hear you, that you think about a cover story, that you make sure that where you meet them can't be observed, that their interaction with you is protected. And that is all absolutely true. But then you can find yourself in a room with someone and you close the door to make sure that no one can walk in and interrupt you and disturb them. And the last time they were in a room with a closed door with someone who they felt a power imbalance with, or who was in a position of authority over them, was a very bad experience. So the very first thing you've done with the very best of intentions can already, for some individuals, be the wrong thing. So you just need to be very observant and very aware. And I think one crucial component of a trauma-informed approach is to realize that the more individual agency you can provide for that person, the better. So you can explain what you're there for, why you're meeting with them. If they're coming to the court or if they're going to a field office to testify, where will they be sitting? What are they going to be doing? Who's going to be there? How long is it going to take? Just very basic information to reduce their anxiety levels. And also to give them a feeling of control over the process. Because I'm sure Maria will deal with this, but one of the crucial things about sexual crimes in particular is that people feel as if their consent and their agency and their fundamental choice was taken away from them with regards to that incident, or potentially for an extended period of time. So asking them to engage in a judicial process that inadvertently replicates that feeling of powerlessness is very, very unlikely to result in a positive outcome for them, or to make them feel as if they have had a catharsis or any kind of positive experience of regaining some degree of power and control. And it helps as well that you can be trauma-informed and not treat people like they're made of glass. You can be trauma-informed and not make paternalistic assumptions about their level of emotional frailty or personal vulnerability. If you are truly trauma-informed, you're prepared for what their support needs or their security concerns might be, but you don't impose them in a blanket way on the individual. It also means that you understand how trauma manifests in different people. And there is, Regina mentioned that I used to work for an NGO that did training. And no matter who the audience was and no matter where we were, there were always a certain proportion of people who genuinely had concerns about the credibility of a victim who didn't cry when discussing the sexual violence, because that's what a real victim does. If they had a flat effect, or God forbid, if they were angry, if what manifested was barely concealed rage, then for some people who in some cases were less experienced, in other cases were very, very experienced in national law enforcement or for international organizations, there was still an assumption, oh, well, that's odd. There's something suspicious about that. Why are they angry? Why do they keep returning to a certain thing? So understanding the emotional manifestation of trauma is very important in terms of how you can assess what is being said to you, whether that's in the interview or in the courtroom. I also think it's crucial for people to understand, and that includes all of us in our operational activities, in any kind of witness management, any sort of witness engagement, outreach is included, investigations, and especially in the courtroom, and also including the way in which you make submissions to judges. And you mentioned the use of expert testimony, and that can be very important. The way trauma impacts memory is quite understandable for those that are informed about it and who are experienced with it, but isn't necessarily what you would expect from a standing start, especially if you go into it with certain preconceptions. And again, not to in any way preempt what Maria is going to say, but one of the best descriptions I ever heard of that came from Patricia Sellers, who used to be the Special Advisor on Gender at the Yugoslavia Tribunal and is one of my favorite human beings in the world. And the way she described it was that if a memory is an image on a pane of glass or on a mirror, the trauma fragments that image. So all of the components are still there. Breaking a mirror doesn't introduce anything new into the mirror. But what it means is that it's not going to be neat, it's not going to be chronological. It will take additional effort to put those fragments back together so that the image is more immediately discernible. And it also explains why certain individuals will become fixated on one specific shard, because that's the one that's sort of stabbing them in the heart as they go about their daily life. It could be something very sensory. It could be something that doesn't relate to what we view as evidentially relevant. It could be the day before it happened, because in their mind, that's the last day of their old life. And they really keep wanting to return to that in an effort to try and explain to you what they've lost and what's been taken from them. But in some cases, for a judicial process, when time is against you, when you want to stick to what's relevant, when you don't have the luxury of engaging in a therapeutic process, people can understandably become sort of frustrated and say, I don't want to talk about that. We need to get back to this. But that can be extremely upsetting and disappointing and disempowering for the person that you're talking to. So navigating that is one very important way of making sure that you are showing the person respect, but you are there for a specific purpose. And to try and keep that train on the rails can be difficult. The more of that you understand, the better. And it's not something that you need to understand for charitable purposes. It's not something you're doing out of pity or out of some kind of humanitarian impulse. The better your understanding of trauma, the better your ability to adapt your approach to the individual victim or witness in front of you, the higher the quality of the evidence that will result from it. The more efficient the process will be for everyone involved. And it's also a statutory obligation. Regina mentioned Article 68. And I think, again, entirely unintentionally, it's easy sometimes to forget that there are many nouns in Article 68.1. We tend to zero in, because of the nature of the work, on safety and to think about physical threats and retaliation, and people who will be targeted for reprisals if their cooperation becomes known. But we're missing well-being, we're missing dignity, we're missing privacy. And dignity, I think, is one of the most overlooked components there, particularly for victims of sexual and gender-based crimes, because if their experience of a criminal process is extractive, again, as I mentioned, that something is being taken from them, or that they're going to be judged, or they're going to be raked over the coals and questioned and ripped apart for the smallest thing. That's what causes the huge, overwhelming anxiety about the prospect of cooperating, or the prospect of disclosing, or being called to testify. And in that sense, the use of the developments that we've seen here at the court in our trials in the last few years, I think, are really positive, particularly when it comes to agreements in advance between the parties, and not even necessarily something that rises to the level of an agreed fact, but just acknowledging that the vast majority of our cases don't involve the direct perpetrator. At the domestic level, when you're dealing with sexual violence, it is the direct perpetrator who's on trial. It is the direct victim who is the primary, if not the only, witness against them. And it's essentially coming, and I'm not going to very deliberately not going to do a pronoun said, other pronoun said description of that, because that reinforces another stereotype that we have. But it is essentially one person's word against another. The vast majority of the cases that we have here, we're dealing with more remote perpetrators. We're interviewing or we're taking testimony or we're cross-examining individuals who may not have ever personally interacted with the actual accused person who's on trial. So in our cases where we've had that cooperation between the parties and the acknowledgement that it may be something as simple as you mentioned, Regina, the particular euphemism for this body part or this sexual act, we understand what that is in a cultural context. We'll ask them to clarify it once, and then we'll take that as understood. Or it may be the scenario that we've encountered where you can have an agreement between the prosecution and the defense that the act of sexual violence as described by the witness occurred. It's the circumstances around that, the time, the place, the perpetrators, the linkage, that's the issue that's contentious. And if you can come to that agreement, it's not just that it improves the experience for the victim. It is also more efficient in terms of the use of the time that you have in court. It is less antagonistic for everyone concerned. It is more effective in terms of testing their evidence for the facts that are at issue that go more directly to the guilt or innocence of the accused. So it's for the benefit of everyone involved. Again, I reiterate, this is not something that we're doing out of charity. This is something that is in the interests of absolutely everybody involved in the process. One other thing that I wanted to mention is that when we're talking about our activities, we need to acknowledge the fact that I spoke about the degree of control that a victim or witness may feel over the process. Depending on the phase and depending on the activity, we as parties to proceedings have a greater or lesser degree of control. So the way in which you conduct and plan for and arrange and carry out an investigative interview has dramatically more discretion than the experience of testimony. And when you have agreements between parties, when you have expert advice provided by the victim and witness section, and it's very important to point out in many of our recent trials, when you have judges who are trauma informed and who are proactive in the way they manage the courtroom, examination in chief, cross-examination, use of procedural rules, use of Article 56, I think, is something that hasn't necessarily been fully exploited, but I understand and I appreciate that that's very dependent on the phase of proceedings. The ability to properly test evidence, like in the Unwin case, where you have an accused person already, you have a confirmation, a document containing the charges, you know exactly what is being alleged. Then it is less important whether that evidence is tested early in an Article 56 process or later in a courtroom. But it's incredibly advantageous to the victim to, for want of a better term, just get it out of the way early and not have it hanging over them for 2 or 4 or 6 years waiting for the day when someone actually ends up in a courtroom. And getting everybody to be fully educated and informed, including the judges, including the legal officers, including the drivers who are bringing them from the airport, the people who are providing the support to them when they're in the accommodation before they come to testify. All of that requires cooperation, the testimony phase, whereas it involves more individual control at the investigation phase. And also, when we're talking about sexual and gender-based violence, one last thing that I want to emphasize is it's not just a case of not making preconceptions about who is or is not a victim of those types of crimes and how they will react to them. There is also an assumption that when we talk about a trauma-informed approach to SGBV, what we mean is making accommodations for a prosecution witness who's going to come and provide incriminating evidence. That's absolutely not always the case. You 100% can have insiders, you can have defense witnesses, you can have suspects or accused persons that may be both a perpetrator and a victim themselves. The frequency of forced perpetration as a means of blooding someone into an organization, as a means of incriminating them to give a degree of coercive control over them for their future behavior. The level of avoidance of recognition that this is something that happened, that you witnessed, or that your brothers in arms may have been involved in, is a very psychologically complex thing for someone to accept and understand and process. And it's not always the case that evasion is for the avoidance of self-incrimination. It can be something much more difficult than that. So regardless of who you're dealing with, the impact of trauma, the reason why it prevents people from disclosing, and the ways in which you can make the experience of providing information on that not just better than living through the original act. Like, I mean, that's essentially what we're talking about when we say we don't want to re-traumatize you. We don't want talking about it to be as bad or reminiscent as living through it. That's why I say that's an incredibly low starting point to go from. I don't think it is overly ambitious. I don't think it's aspirational or pie in the sky or sympathetic head tilt social worker mindset to think that we can go so far beyond not making it worse, and you genuinely can create the conditions where someone's ability to process and move on from what they experienced is empowered and driven and added to by the fact that, yes, it absolutely can be vindicating to provide a statement and be listened to and respected and believed. It can be fantastic to come to court, testify under oath, feel as if you spoke up for yourself to the person you hold responsible, but also to be shown respect by all of these fancy people in their ridiculous cloaks and all of these various interpreters and the massive big room. But just to feel as if you had your say, that step in your mental processing, that inflection point, that piece of punctuation to say, that was the end of one chapter, this is the beginning of another chapter, that's achievable regardless of the verdict. But the verdict is likely to be more accurate and more easier to justify, whether it is a conviction or an acquittal, if everyone involved has taken a trauma-informed approach and you know we didn't get to this point. Conviction, acquittal, good or bad, depending on your perspective, by exploiting someone, by mistreating someone, or by resorting to lazy or uninformed assumptions about what a real good victim or witness should do, or how they should respond, or what limited accommodations we should be willing to make for them to avoid re-traumatizing. So I'll stop there.
Thank you so much, Nick. That image of the mirror and the breaking of the glass You know I'm going to use that.
Oh, it's Steve. It's not even mine.
Completely stolen.
It's not even
I'll
mine.
give credit to both you and absolutely, I'll do that. But that's, I mean, it's just such a powerful image in the way you see that the pieces are all there, but they just need to be put together in a different way. Thank you so much for your insights. That's incredible. And hopefully there'll be a lot of questions for me along the way to give us a few more of your valuable wisdoms. Cecile, we will pass to the guests, but you're going to do French, huh?
Yeah,
Yes, of course. We have a lot of French colleagues, and just because I'm an Australian that even has trouble speaking English most of the time, doesn't mean that you should be speaking in French. So I'm really grateful that you are able to do that for us, particularly for our French-speaking colleagues around the world.
exactly. It's because we have a lot of French speakers at the ICCBA. So
Yeah,
it's
exactly.
also for them.
Yeah.
Probablement que je vais répéter certaines choses que ma collègue Nive a dit. Et je voulais commencer par parler des enquêtes, mais en fait, avec tout ce que vous avez dit à propos du traumatisme des victimes, j'ai envie que mon premier point soit la formation, en fait, parce que je pense que en défense, on a énormément besoin d'être formés sur toutes ces questions-là. On peut avoir des équipes de défense avec une personne, un avocat qui va arriver sur une affaire et qui n'a jamais au national fait de contre-interrogatoire ou d'interrogatoire de victimes de violences sexuelles de genre. Donc, je pense que c'est très important qu'on mette en place des systèmes de formation des avocats et des équipes de défense en général. Parce que en plus la défense a des moyens limités, donc pour le procureur par exemple, ils vont avoir une équipe qui gère les enquêtes et qui est assignée juste sur les enquêtes, donc va aller sur le terrain et parler aux victimes et être habitué à faire ce genre de choses. À la défense, l'équipe fait tout, que ce soit les enquêtes, le procès, tout ce qui concerne l'avant et l'après. Donc, bien sûr, il y a moins de compétences spécifiques de base pour ce genre de problématique. Justement, Nive, vous parliez de tout ce qui est des comportements parfois déstabilisants des victimes qui peuvent être agressives ou au contraire indifférentes, très agitées, désorientées, ne pas pouvoir savoir comment se repérer pour leur expérience dans le temps et l'espace. Ça, c'est des choses auxquelles on n'est pas du tout confronté, on n'est pas habitué. Donc, d'où le besoin de formation là-dessus. Et sur tout ce qui est aussi le caractère intime et dégradant des violences et les sentiments ressentis comme la culpabilité et la honte. Donc voilà, ça c'est mon premier point qui est sur la formation elle-même des équipes de défense en particulier, qui peut venir de, je sais pas, la ICCBA ou la cour elle-même, probablement qu'on aurait besoin de la cour là-dessus. Et peut-être en partenariat avec le procureur et l'unité des victimes et des témoins. Je sais que vous faites des choses aussi dessus. Voilà, ensuite, je voudrais parler de la phase d'audience elle-même, qui est une phase assez délicate pour la défense, parce que non seulement d'un côté, on a les besoins des victimes de violences sexuelles et de genre, qu'elles soient respectées, leurs besoins soient couverts, mais d'un autre côté, on ne doit pas compromettre les droits de l'accusé, du suspect, du condamné. Donc c'est très important qu'on puisse avoir un équilibre entre la protection de la victime et les droits de la défense. J'avais un exemple que j'ai trouvé très intéressant, qui est une affaire qui a été rendue par la Cour européenne des droits de l'homme au début de cette année, en février 2023. L'affaire s'appelle B contre Russie. En gros, la Cour a reconnu que la responsabilité de la Russie était engagée à cause de ces procédures judiciaires qu'elle a considérées comme entraînant une victimisation secondaire pour la personne qui a vécu le traumatisme. Donc, en gros, ce qui s'est passé, c'est qu'il y a une personne qui avait été victime d'abus sexuels pendant son enfance, qui a rapporté ses abus à l'âge adulte. Il y a une enquête qui a été ouverte et un procès. Et durant toute cette phase d'enquête et de procès, la personne a été soumise à des auditions répétées, donc énormément d'auditions, a été mise en face de ses agresseurs, donc a subi tout un processus judiciaire qui lui a causé beaucoup de stress et de souffrance mentale, et donc qui a conduit à des troubles psychologiques et à un nouveau traumatisme pour cette victime. Donc la Cour a condamné la Russie là-dessus. Donc, en partant de ce constat, il faut donc noter que le processus judiciaire peut potentiellement faire revivre à la victime le traumatisme. Et pour la défense, le problème est de potentiellement remettre en cause la qualité de victime par les questions qu'on va lui poser. Donc c'est là qu'il faut travailler. Donc, quelque chose qu'a mentionné Regina, c'est les faits qu'on peut établir avant le procès, donc ce qu'on appelle les agreed facts. Donc, c'est-à-dire se mettre d'accord avant de commencer le procès sur l'établissement de certains faits. Du point de vue de la défense, on ne pourrait jamais accepter avant le procès de dire que cette personne a été victime de violences sexuelles. Pourquoi? Parce qu'il me semble que c'est la responsabilité du bureau du procureur d'établir les faits. Donc, pas seulement la responsabilité de l'accusé, mais aussi les crimes eux-mêmes. Donc, ça fait partie du processus judiciaire. Le procureur doit prouver que les crimes ont lieu. Et c'est aussi important du point de vue de l'aspect performatif de la justice pénale internationale. Donc, c'est aussi pour la communauté, établir que des violences sexuelles ont eu lieu, c'est important. Donc, on ne va pas accepter à l'avance dans des faits établis que la victime a subi des violences, tout comme on ne le ferait pas pour une victime de pillage ou de torture, par exemple. C'est la même chose là qui s'applique pour les violences sexuelles. Donc voilà, et je pense aussi qu'on peut quand même envisager que la victime elle-même veuille raconter son histoire. C'est possible souvent on part du principe que la victime ne va pas vouloir raconter à nouveau ce qui lui est arrivé, mais d'un côté, la participation des victimes au processus judiciaire peut avoir certains aspects bénéfiques pour elles, pour pouvoir non seulement évoquer les psychotraumatismes, mais aussi être reconnue comme victime par une autorité judiciaire. Donc ça peut être important et ça peut contribuer à la réparation, une forme de réparation du préjudice, d'être à même de pouvoir l'exprimer devant un tribunal. Donc, on a besoin que les faits soient établis par le tribunal. Ce qu'on peut dire, c'est qu'on n'a pas besoin qu'il y ait un millier de victimes de viol, par exemple, qui viennent en audience et expliquer qu'elles ont été violées. Et c'est là où le travail du bureau du procureur est important pour le processus judiciaire, c'est de pouvoir trouver quelques victimes qui sont résilientes, disposées à témoigner et à pouvoir être en mesure d'expliquer ce qui leur est arrivé et de supporter ce processus judiciaire globalement. Et donc, on sait bien que le procureur doit prouver dans une affaire 3 éléments. La première chose, c'est que les crimes ont eu lieu. La deuxième, c'est que les crimes puissent être qualifiés de crimes contre l'humanité, crimes de guerre ou génocide. Et la troisième, prouver le lien entre les crimes et l'accusé. Donc, nous, notre travail à la défense, il va se concentrer principalement sur le troisième aspect. Et donc, après, lors du contre-interrogatoire, on ne va pas revenir systématiquement sur le fait que les crimes aient été commis et sur leur qualification. Donc là, peut-être que j'ai l'air de vous contredire un peu, j'espère pas du tout. Ce que je dis, c'est que les crimes doivent être établis par le procureur en interrogatoire. Et une fois que la défense, c'est son tour d'intervenir en contre-interrogatoire, on ne va pas forcément remettre en cause le crime dans le contre-interrogatoire. Donc, ce qu'on fait, nous, dans la pratique, c'est qu'une fois que le procureur a établi les faits avec la victime, par exemple, on peut choisir de ne poser aucune question. Si le procureur a établi par ses questions la violence sexuelle, mais qu'il n'y a pas de lien avec l'accusé, que ça n'a pas été évoqué, la défense n'a pas besoin d'intervenir dans ce cas-là. Si des fois, il y a besoin quand même de remettre en question certaines parties du récit, et généralement, la défense va intervenir sur des questions d'identification des auteurs du crime, donc pas toujours par le crime lui-même, les auteurs, ou la date, le lieu, essayer de ce qui peut être compliqué, bien sûr, pour tout ce qu'on a évoqué avant, mais poser plutôt des questions sur le contexte plutôt que sur l'événement traumatique en lui-même. Par exemple, c'est ce qu'on a fait dans l'affaire Benba. On n'a jamais contre-interrogé les victimes sur le fait qu'elles aient été violées. Donc, on n'a jamais remis en cause leur qualité de victime et les épreuves qu'elles ont subies. Donc, en leur évitant de répéter la violence sexuelle et raconter encore les mêmes faits, on limite en tout cas la retraumatisation. C'était le but. Donc, ce sur quoi on s'était concentré, c'était le lien entre les crimes et l'accusé. Donc, par exemple, en essayant de démontrer, par exemple, que l'auteur de la violence sexuelle n'était pas un membre des troupes de M. Bemba, où on a pu essayer de se concentrer sur le champ géographique ou le champ temporel de la violence. Donc, démontrer que la violence a, on va dire, par exemple, plutôt eu lieu à cette époque de l'année, c'est-à-dire, par exemple, poser des questions, est-ce que c'est la saison sèche? Donc, dans ce cas-là, ça ne rentre pas dans le champ temporel des charges, par exemple, ou si la victime se trouvait dans une ville ou un endroit du pays qui n'est pas couvert par les charges. Donc, c'était plutôt un contre-interrogatoire contextuel, le plus loin possible du récit de la violence, pour ne pas aussi que la victime revive l'événement en question ou se sente attaquée sur son récit et les choses qu'elle a vécues. Voilà. Alors après, bien sûr, il y a des situations où il est important quand même pour la défense de remettre en cause la violence sexuelle elle-même. Parce que, vous l'avez évoqué, des fois, la plupart du temps, les accusés sont loin du crime, donc pas accusés personnellement du crime, mais ça peut arriver parfois qu'ils soient accusés en tant qu'auteur direct. Donc, on va vouloir faire en sorte que le crime ne soit pas établi. Ça fait partie de notre travail. Donc, dans ce cas-là, une solution qui peut être importante et qu'on a la chance d'avoir ici à la Cour pénale internationale, c'est ce processus de familiarisation qu'on a avant l'audience. C'est-à-dire qu'avant que la personne victime témoin vienne, on a ce processus qu'on appelle familiarisation ou courtesy meeting, où la victime va venir dans la salle d'audience et on va lui montrer où se trouve la défense, où se trouve le procureur, le juge, où l'accusé va être assis. Et chaque partie va venir dans la salle d'audience et va se présenter à la victime. Et donc, pour les victimes de violences sexuelles, je trouve que c'est une bonne occasion de pouvoir, à ce moment-là déjà, la victime va voir le visage de la personne qui va lui poser des questions en audience. Donc, elle arrive en audience, elle n'est pas complètement dans un inconnu. Donc, c'est ce dont vous parliez à propos du contrôle aussi, de savoir un peu qui elle a en face d'elle. Ensuite, ça peut être aussi le moment de la rassurer et lui dire, parce que la plus grosse angoisse, c'est de ne pas savoir ce qui va se passer pendant l'audience. Donc, peut-être expliquer le rôle à ce moment-là de la défense. Donc, notre rôle, c'est de défendre les intérêts de notre client. Donc, c'est notre métier, c'est ce qu'on doit faire. Il n'y a rien de personnel dans le fait qu'on va devoir aborder des sujets qui sont très difficiles et traumatiques. c'est pas contre la victime, ça fait partie du processus judiciaire. Et je pense qu'on peut trouver les mots et les moyens d'expliquer à la victime ce qu'on va faire et pourquoi on doit lui poser ce genre de questions et que c'est notre métier et comment ça va se passer en audience. Aussi à ce moment-là, probablement le rôle de l'unité des victimes est très important pour essayer en amont de toute cette protection contre la retraumatisation en audience. Ensuite, des techniques qu'on peut utiliser en audience, à mon avis, c'est peut-être signaler à la victime le moment où on va aborder des questions plus intimes ou difficiles. Donc, par exemple, faire ce qu'on appelle un trigger warning. Donc, peut-être dire, pour l'instant, je vais poser les premières questions sur le contexte, où vous étiez, ce qui s'est passé. Et après, au moment d'aborder la violence sexuelle en elle-même, si on doit le faire, dire, prévenir la victime, voilà, maintenant, je vais vous poser les questions qui vont potentiellement être plus compliquées pour vous, voilà. Ensuite, une troisième technique, il est toujours possible de vérifier qu'une personne a vécu des violences sexuelles sans poser tout un tas de questions sur l'acte en lui-même. Par exemple, on peut poser des questions qui tournent autour. Par exemple, tout ce qui est question à propos de la réintégration dans la communauté ou les liens avec la famille, parce qu'on sait qu'une violence sexuelle peut exclure une victime de sa communauté ou même de son cercle familial. Et donc, en posant des questions là-dessus, de cette manière, on peut aussi établir la violence sexuelle. Aussi les difficultés sur les grossesses qui ont suivi, sur les enfants, les difficultés médicales, ou si on ne veut pas aborder ces questions en particulier, un outil qu'on utilise beaucoup aussi en défense, c'est des contradictions entre les déclarations écrites et ce que la personne raconte en audience. Donc, essayer d'exposer les exagérations, les omissions, des choses comme ça pour remettre, si on a besoin de remettre en cause la parole de la victime sans entrer dans des événements trop traumatisants. Il faut prendre en compte, bien sûr, le phénomène de mémoire traumatique dont on a parlé, et que le fait que certains événements peuvent être oubliés ou la manière dont ils sont racontés sont décousus, donc pas avec une trame chronologique. Donc, on ne peut pas demander à une victime d'être précise et cohérente. Et donc, pas la pointer du doigt en audience pour son incapacité à retracer son récit. En tout cas, en audience après, à la rigueur, ça peut être fait plus tard à l'écrit dans des soumissions écrites finales sur... c'est à ce moment-là que les incohérences peuvent être pointées. En audience, on peut éviter de... confronter trop durement la personne sur ces aspects pour essayer de respecter sa fragilité et sa dignité. Voilà. Aussi, le choix des mots, bien sûr, est très important. Donc, tout à l'heure, on a parlé du concept que, par exemple, le mot viol, selon les cultures, déjà, c'est pas forcément le même. Des fois, il y a des langues, dans certaines langues, on n'utilise pas du tout le mot viol pour dire qu'une personne a été violée. Je ne pense pas que la défense accepterait comme un fait établi de dire tel mot veut dire, quand si la victime dit tel mot, ça veut dire viol. Ça peut être accepté en audience, c'est-à-dire qu'on peut demander, le procureur peut le demander une fois à la victime et demander ensuite si la défense accepte. Et à ce moment-là, à l'audience, la défense va dire « Ok, c'est établi ». Par exemple, on est d'accord qu'à partir du moment où la victime va utiliser ce mot, elle parlera de viol, comme ça on n'a pas à revenir à chaque fois sur le mot et à lui faire répéter et répéter. Il se peut, c'est possible qu'on en vienne à passer par un moment de description et que la victime ait à dire cette personne à utiliser telle partie de son corps pour pénétrer telle partie de mon corps. C'est possible, mais une fois que c'est fait une fois, après, il n'y a plus besoin d'y revenir et c'est établi en fait en audience. Mais préalablement, pour la défense, ça serait difficile de accepter ça avant d'avoir la personne en face et toutes les raisons que j'ai mentionnées aussi précédemment. Donc, la défense a bien sûr un rôle à jouer dans le fait d'éviter, de limiter, d'éviter la retraumatisation, en essayant de la prévenir, la limiter, mais malheureusement, tout ça doit être équilibré avec, malheureusement, heureusement, avec les droits fondamentaux de l'accusé. Surtout qu'un autre point que je voulais signaler, c'est que on fait face à un biais cognitif de base, c'est-à-dire que du fait qu'on va qualifier une personne, un témoin de victime, automatiquement, le cerveau humain croit que cette personne est une victime. Donc, bien sûr, ça a un impact sur les droits de défense parce que tout le monde arrive en audience en disant « Ah, cette personne, elle est une victime ». Donc, c'est très, très difficile après pour la défense de faire son travail de remise en question de ça s'il y a besoin pour la défense de la personne accusée. Donc, c'est pour ça qu'aussi, c'est très important qu'en amont, la victime soit prise en charge avant qu'elle se retrouve face à la défense, par notamment l'unité des victimes et des témoins, pour expliquer tout ce processus et ce par quoi on va passer avec nos questions. Voilà. J'ai trouvé très intéressant aussi la mention de l'article 56 du statut de Rome, qui peut être aussi compliqué pour la défense, mais je pense que c'est quelque chose qu'il faudrait creuser. Ça, moi, je n'ai pas eu l'expérience dans les affaires sur lesquelles j'ai travaillé. Et je trouvais ça intéressant qu'il y ait la possibilité de nommer des experts pour prendre des témoignages en amont. Et je pense que ça, ce serait aussi un processus auquel la défense peut participer pour avoir justement cet équilibre entre protection des victimes et droit de la défense à ce stade, avant si on doit prendre des déclarations préliminaires au procès. Voilà. Je voulais parler un peu de la phase d'enquête. Donc, préalable au procès, parce que la défense aussi est amenée à faire des enquêtes sur le terrain. Donc c'est ça que j'ai mentionné aussi au tout début avec ce besoin de formation, c'est-à-dire que c'est l'équipe de la défense elle-même qui va sur le terrain et fait ces enquêtes, donc, et pas du tout, ou pas forcément formée aux problématiques des violences sexuelles et de genre, peut être amenée à rencontrer des victimes dans le cadre de sa défense, parce que aussi, on est aussi amené nous-mêmes à appeler des victimes de violences sexuelles, peut-être par exemple pour prouver que d'autres groupes armés ont commis des violences et que ce n'est pas seulement le groupe de l'accusé. Donc dans ce cas-là, je vais faire rapidement parce que Nive en a beaucoup parlé, mais il y a des techniques à mettre en place pour l'accueil des victimes de violences sexuelles. Donc, bien sûr, il faut qu'elles se sentent dans un climat de sécurité, confiance et aussi confidentialité. Et la confidentialité, je pense que ça repose sur la protection de leur identité, mais aussi la protection de leur vie privée. Et ça, je le dis aussi sur la phase de procès. Mais ces victimes ne veulent pas forcément que leur famille, même leurs plus proches, leurs conjoints, enfants, mère, père, ne sachent qu'elles ont été victimes pour des raisons qui pourraient les amener à être exclues de la communauté. Donc, c'est très important aussi de rassurer les victimes sur ce point de vue-là, pas seulement la protection de leur identité vis-à-vis du public général, mais aussi de leur propre famille. Voilà. On a parlé du lieu qui est important. Moi, j'avais vraiment le point de vue mettre la personne dans une situation où elle est au calme, qu'elle sait qu'elle va parler dans un climat de confidentialité et éloigné de personnes qui pourraient entendre. Après, j'ai trouvé le point de Nive très intéressant sur le fait qu'être enfermé dans une pièce avec une personne peut potentiellement être traumatisant pour la personne. J'avais pensé aussi au nombre de personnes présentes lors de cet entretien parce que quand on va sur le terrain, on peut être une équipe très nombreuse entre l'enquêteur, l'avocat, les assistants juridiques, la personne ressource, les intermédiaires, les traducteurs. Donc peut-être penser à limiter le nombre de personnes qui va être en entretien avec la victime, donc peut-être 2, 3 maximum s'il y a besoin d'un traducteur, mais que la victime n'ait pas à devoir raconter son histoire à 6 ou 7 personnes là d'un seul coup en face d'elle. Ça, je pense que c'est important et adapter ces techniques d'entretien, donc la durée notamment, penser à faire des pauses, à demander à la personne si elle a besoin de pause et à éviter peut-être la répétition des entretiens. Donc pour ça, la technique, c'est probablement l'enregistrement audio ou vidéo sous réserve du consentement de la personne. Mais ça permet, l'audio et la vidéo, ça permet peut-être d'après pouvoir réentendre ou revoir l'entretien. Et s'il y a besoin de revoir la personne, vraiment sur les points qui ont besoin d'être éclaircis. Et ça permet comme ça de limiter les entretiens plutôt que d'en avoir 8 et à chaque fois devoir revenir sur des points, alors que si on a fait le travail avant, préalablement, de revenir sur l'audio et d'avoir juste les questions précises sur les points qui nous manquent. Ça aussi évite probablement ce phénomène de retraumatisation, d'avoir à répéter à chaque fois la même histoire très souvent. Voilà. Et bien sûr, les explications. Donc ça, c'est également ce que vous avez abordé sur le contrôle. Toujours expliquer tout. D'abord, qu'est-ce qu'on fait là? Donc, est-ce que si on prend une déclaration écrite, à quoi elle va servir cette déclaration? Qui est-ce qui va y avoir accès? Qu'est-ce qu'on va en faire? Si on demande à la personne de venir plus tard témoigner, dans quelles conditions, quand, combien de temps ça va durer, c'est quoi le processus judiciaire? La personne a besoin de savoir pourquoi elle est là, ce qu'elle fait. Et qui on est, c'est quoi notre rôle dans tout ça, qu'est-ce qu'on va faire de ce qu'elle nous dit et qu'est-ce qu'on cherche à faire avec ses paroles et les personnes qu'on rencontre en général. Aussi, probablement les droits de la personne elle-même en tant que victime ou en tant que témoin. Et puis, voilà à peu près ce que je voulais dire. Et aussi le rôle de la défense à ce moment-là, parce que, encore une fois, les moyens, à cause des moyens limités et le fait que c'est la même équipe qui est ici présente à la cour et qui va sur le terrain, peut-être demander un suivi des personnes victimes de violences sexuelles et de genre avec l'unité des victimes et des témoins, chose que nous, on va avoir du mal à faire régulièrement vu tout le travail qu'on a à accomplir au quotidien. On a l'unité des victimes et des témoins qui est là pour ça, pour nous aider et pour prendre en charge les victimes après qui peuvent avoir des demandes de prise en charge sur des questions de soins ou physiques ou psychologiques auxquelles nous, on ne peut pas répondre en tant qu'équipe de défense. Donc, pour ça, on travaille aussi avec les autres unités et sections de la Cour sur ces questions. Voilà.
Thank you so much for what I think must have been a very informative discussion, because I can see you nodding a lot. I'll take my comments from you. Thank you for that, and there'll be time for questions afterwards, of course, which you're taking in French and English.
Yeah.
Okay, brilliant. Thank you very much. Marie-Clara, if I can turn to you, you have the floor.
Hi everyone. Yeah, it feels a bit it's a difficult position to be in the last one, because I feel like everyone's already presented things so well. But so I'll try to focus a little bit on the types of things that we do. VW, SPW, both things. Rome Statute says VW, so it's tricky. So of course, when the Rome Statute on Article 43, it establishes the registry and it specifies the creation of the VW units, and it lists that the unit shall include staff with expertise in trauma, including trauma related to crimes of sexual violence. So literally that is my job. It's stated right there. This is the need it established from the very beginning of the court, and this is this shows how much awareness there was already on the need for a trauma-informed approach. But I think, of course, I feel like with the interaction, I don't have that much interaction with the colleagues from the defense or OTP on that matters, on a lot of the matters that were discussed today. But I love to share the responsibility in terms of the trauma-informed approach. I think it's really important that I tend to think of it all as my job, but it's everyone's job indeed, because yeah, this is in the process of obtaining evidence, as both of you have already said, this increases the quality and the efficiency of the process if we maintain that approach. So I took several notes as you were both speaking, and I'll try to comment that as well. But at first, I would just like to we talk about trauma, and I'm assuming that we all know what it is, but on a psychological diagnostic level, it involves the experience of an event that is lived. The same thing could happen to me and to you, and we might take it as something that raises a lot of emotions, and for you maybe not. So the same thing we can call something, oh, this is a traumatic event. Not necessarily, it's not exactly what happens, but it's how it's experienced by the people. But of course, there is a very high rate of trauma developing from sexual and gender-based crimes. And I love the mirror example of the formation of the traumatic memory, and that kind of have another metaphor by how the development of trauma. If, for example, people are hit by cars, I think it's safe to assume that most people are going to be harmed by it, or some kind of injury they're going to suffer. Some is going to be just a scratch. For others, it's going to be death. For others, it's going to be lifelong consequences of it. But I recall once I met an actor who took a course on stunt, and she and her husband was actually hit by a car, and he activated the skill that he learned, and he just rolled over the car and he fell standing completely unharmed. That is quite exceptional. But so we don't assume that everyone is going to have that skill, that level of resilience to go completely unharmed by an impact so intense. So, but we can assume that most people are going to be somewhat harmed by the experience of sexual and gender-based violence. So in our processes, we always talk about the vulnerable witnesses. Of course, my job is to evaluate victims and witnesses who come to the court, and I will do that for everyone. Of course, we're going to pay particular attention to the ones that have already been flagged by the calling parties, the defense or the prosecution or the LLBs. We're going to pay particular attention to those that are deemed vulnerable on forehand. But as you said, we don't make assumptions of how they're going to present what they're going to be experiencing. So a trauma-informed approach is useful for life.
Yeah.
It's not useful for interacting with the victims of sexual and gender-based violence. It is useful for any witness, even sometimes for an expert witness who comes to testify. I still do meet and assess everyone, because sometimes they're going through a difficult personal, sometimes they have a health issue that we need to take into account. So the expert witnesses who are people who we will not consider vulnerable beforehand, they might have at this moment something that a particular circumstance that might require some additional attention. So when we talk about the vulnerable witnesses, we define them as the witnesses who are at an increased risk of to be psychologically harmed because of their involvement with the court, or to experience difficulties during the process of testimony. And in our regulations and all the legal documents of the court, the typical criteria for vulnerability that we describe are the nature of the crime, such as SGBV or crimes against children, factors related to the person, such as age, if they have some type of disability, if they have a history of mental health issues, and particular circumstances such as an acute health problem or stress related to potentially relocating or so, or if they're concerned about their safety when engaging with the court. So many of these things that are criteria for vulnerability, things that we consider about, they are actually part of people's identities. So I think it requires that we have part of a trauma-informed approach is to have an intersectional view of who these people are. It means that it's not just it's a woman victim of rape and she should behave like this and that, like the stereotypical image that we have of a victim. But we're talking about people who have a compound, each aspect of who they are compounds to their experience, if they are literate or not, if they have an experience living abroad or not, if they have ever traveled. Sometimes the whole process of coming here, the cultural shock is already something that triggers a lot more than it would under their normal circumstances. So racial matters, age, all that. This is all a part of people's identities, and it has an impact on how the trauma expresses and how they experience their participation with the court. So we all understood the process of the traumatic memory and how it's all there. It's just much more complex to retrieve. Because and we tend to think that a lot about the negative events, but also positive events. They can be hard to trigger if they were stored in a moment of intense emotion. I recently heard the story of someone who complained to her father that he didn't dance with her on her wedding day. And he said, "What are you talking about? There's a video recording of us dancing," but she was just in such a heightened state of emotion, of thrill, that was very happy, that she does not have the recollection of dancing with her father on her wedding day. Right. So this type of, and also we have this type of sensory memories that for traumatic event, they tend to be stored as just the sensory, like raw content, instead of a verbal account of what we lived and we store in a nice filing system in our brain. It tends to be very scattered and sensory, but we can also have that for good events. Like when we think about a good day on vacation where the smell of the flowers or fresh coffee in the morning, and the nice feeling we had when we hugged someone after not seeing them for a very long time. We recall the sensory pieces, but the stress level wasn't there to make it scattered, to make it difficult for our brain to process it. So we also spoke about how someone might react being very high on stress or arousal when they talk about something that means that they are outside their window of tolerance, their usual zone in which they would be their calm, collected, and give their best. They're in their best state of mind to present a story or to talk about something. And also that can be hyper arousal or hypoarousal. That can be also in some way at the associative level. That means when their affect is very flat. That doesn't mean that they're not suffering from it. In fact, that is actually a symptom that they are suffering from it. That is the way that they found to cope. And so this issue of credibility is all very interesting for me. But even though we don't address credibility of witness, it's not my job to assess the credibility of a witness. But we understand how that might present for others in the courtroom. I also heard once from someone who treats people, from a psychologist that treats people with EMDR, which is standard treatment for trauma, and she said that tends to make people so much more calm and collected because they have already processed the traumatic experience that sometimes she feels like she has to send a report that disclaims that this person is not going to act the way someone who hasn't processed the trauma would in the courtroom, because this has been treated, and this is good it's good for the legal process, as you explained, that the quality of the evidence will be better because it has been properly addressed and treated. It will not push this person outside their window of tolerance when talking about it. So it will be less difficult to elicit the quality information, less distressful for the person, less stressing. So there are several things that we can do in the process of testimony that to follow this trauma-informed in all our interactions with victims and witnesses. Many of them have already been described here. I think providing some type of, in the moment that the traumatic event took place, the person didn't have a choice. So if we give as much choice as we can, that is ideal. That can, of course, we cannot choose about, for example, the presence of the accused in the courtroom. We cannot say, let's remove the accused. It's the accused person's right to be there. But if the level of stress of this person is that intense, we can, in our special measures that we recommend, we can request the chamber to have the person testify from a different room, via video link or so. If the person has an intense fear of eye contact, we can place a screen in the courtroom. If I'm particularly concerned about how this person is going to act in the courtroom and their reactions, and I feel like this person will need closer monitoring, I can request to be there in the courtroom or to have an in-court assistant sitting close to the person. And there can be some type of sign agreed to, okay, this is, I need a break, I need a moment, and we can then inform the court officer that, okay, this is a moment for a break. So these are ways to offer choice an agency to this person. We can also, sometimes depending on the composition of staff, we cannot offer that much choice of gender of who is interacting with them. Also, the availability of interpreters, we don't always get to choose, but whenever possible, we should give that offer. Whenever possible, we can offer them a different, the choice on which time would they rather do something. After this or before this, or in the afternoon or in the morning, today or tomorrow. If you can offer choices on things that to us would be irrelevant or absolutely simple or easy to implement, why not offer these choices? Because if we give them as much control as possible, we are that helps in the development of our rapport, of our relationship with them, and that makes a big difference in how they experience the interaction with the board. Developing trust is very important. We don't always say things that they're going to like to hear. And we shouldn't treat them as a glass that can break. Sometimes we have to say hard truths, as long as it's truth. And they know what to expect. Sometimes we're going to say, this is how it happens. The accused is going to be there. You're going to be cross-examined. That is part of how it goes. And sometimes just giving them as much warning as a heads up as possible. That is creating some sense of predictability. You spoke about the familiarization. That is absolutely core of what we do. That we present the courtroom to the person. No one that testifies is in the courtroom for the first time at the moment of their testimony. They have visited the courtroom before. They have been explained about how interpretation works. They have been explained, okay, this is the person that is on the side of the defense who's going to question you. This is the person from the side of the defense who will question you, and this is the person from the side of the prosecution. You will also get questions from the judges. This is how. This is why we need to speak slowly and this because of the interpretation, but still, even though there is a set time to start this, we're providing factual information that they can refer to, and we try to prepare them as much as possible to the usual times and dates that were. There's a lot of change in the schedule, and we deal with that a lot in informing them firsthand. But whenever we're dealing with vulnerable witnesses, it's best to avoid changes to the schedule that are last minute as much as possible. Because if someone is mentally prepared, okay, it's going to be tomorrow, they say no. The witness for this morning just took one session. Let's bring him in this afternoon. All of a sudden that can throw the person completely off, and that is far from ideal for a particularly vulnerable witness. So yes, we try to give as much predictability as possible, and for everything that we do, we try to obtain informed consent. Informed consent is key to our work, and they don't go through an interview with a psychologist if they don't want to. They don't proceed if they don't feel like continuing an interview. No one is forced to go through it. And we also try to offer, they're also entitled to ask for a break during the courtroom if they're distressed outside of the usual scheduled breaks. So most clients, they are greatly reassured once they're informed of that. Once they're informed, okay, if you raise your hand, the judge will address you, and you can actually request a break. That gives them some sense of control. You have a choice in this. The environment of safety. Many clients are also very reassured once they realize, okay, there's no way you're going to bump into anyone in your way to the courtroom. the access from our premises to the courtroom is completely safe. You're not going to run into the witnesses. You're not going to run into the accused. You're not going to run into anyone until you reach the courtroom. And there is where everyone, as we said, they're going to be. This helps provide some sense of safety. Our premises are safe and quiet and comfortable to receive them prior to their testimony. And in terms of safety, one thing that is usually a standard thing for psychologists, which is the absolute confidentiality. That is something that is always, that is a key component of our profession and our practice. There's a limit to our confidentiality when we work in a legal setting. So when we interview them, and if we feel the need to put in place special measures to help them in their testimony, we do need to disclose certain information. We will have to disclose it, but we don't disclose it to the parties. We disclose it exclusively to the chamber, only to the staff that needs to know, and as minimal information as possible, only in order to justify concretely what we're doing. We're trying to justify why are we requesting this in this measure instead of that. It's because this happened during the interview, and we feel like this will be the best way to address it, or in agreement. And we also always agree with them before we request the special measures. We say, I think that this and this and this could help you in your testimony. Would you agree with me? If they are in agreement, then we circulate this. And if they, and also the same thing for not requesting special measures. I believe, based on our interview today, that you don't need any special measures. How do you feel about that? So we always try to have this collaborative and respectful attitude towards them, in the sense of providing them a minimum level of control over things that we cannot control, things that are provide some predictability, even though we stress that change happens in the courtroom. And so this is our part of what we do in our process. So we tried, Nico already said that the do no harm is the basic principle of everything that we do, is the basis of what we do. It's part of our mandate, it's part of our it's the core of what we do. But if we put the person on the center, being aware of all their potential vulnerable factors, all their factors about their identity, about all the intersectionality, as how all that rules or a change or has an effect on their experience at the moment, that is a very key component of a person-centered approach, about a trauma-informed approach, about the client and victim-centered approach. And being acting or providing a safe relationship, supportive, empathetic, and compassionate and trusting, these are key components to developing a good rapport and relationship, because most traumatic events, they happen in relationships. Many traumatic things happen in the relationship, and a way to try to prevent victimization is to enforce our professional relationship with them. Because when we talk about PTSD, for example, one of the key definitions of clusters of symptoms is what we call avoidance. People tend to avoid places, people, or anything that is connected to the traumatic event. And of course, one of the things that they're going to avoid to do is talking about it. So it is the most basic way to trigger someone, is to ask them to talk about it. And so this is something we cannot deviate. But everyone here was also made great examples of how can we talk about it in the least re-traumatizing way? How can we ensure that we don't touch again and again and again on the topic, or how can we agree on some facts beforehand, or how can we go discussing the context in which it happened instead of discussing the actual event? So this is a way to avoid re-traumatization, because the key, the thing is, people who have such scattered memory, it's hard to predict what will trigger. It's hard to predict which information also will be useful to them in reassuring them. Sometimes in the process of explaining, okay, this is what's going to happen, and this is on the day of testimony, this will happen, this. Sometimes a piece of information that I would never expect, that the person feels, oh, that's so reassuring to know. Okay, out of all the information that I was going to give to this person, I was not expecting this to be the reassuring piece of information. But because we don't know what will trigger this person. So we try as much as possible, as we have all said, to provide them some sense of, this is what is going to happen, this is how it's going to happen, this is the people you're going to be interacting with, and you have a choice of this or that, and giving them that sense of control, of choice, that can make a big difference for them. We also know that even though some people have a difficult time in the courtroom, and they might struggle with their testimony, very often we expect, okay, there were so many additional breaks, this person felt distressed, cried, and this happened. In the end, sometimes I expect them to come like a bit broken afterwards, and on the contrary, it is the sense of, it was so hard, but I made it. It's the resilience and the strength of many of the victims and witnesses that come to testify is absolutely incredible to me, and I feel very privileged to see that firsthand. I feel privileged to have their trust to recollect their stories and to help think of ways to make their experience in interacting with the court something that most of them have been waiting to do. They're looking forward to do it. Some are terrified and wish to do it anyway. And I feel very privileged to be able to assist all sides of the judicial process in their interaction with the court. And so what can I say about the development of trauma overall? There is, of course, how the traumatic experience can sometimes, by knowing what happened, we can already expect some type of trauma. But of course, everyone is unique. Everyone's experience, like in the car hit scenario, if someone had already a broken leg before, the way that the time that it will take for them to heal is completely different. How old they are when it happens. Even though in a trauma, if a trauma happens to someone of a very young age with still a developing brain, that can have long-lasting effects for some particular reasons. But on the same way, because their brains are still developing, we can also foster and promote resilience and an improvement on the way that they're gonna recover from it. So and for an older person, the capacity to recover for something might not be as good as for someone that is younger, or for someone who has a previous history of trauma. It will be different how they're gonna develop it. So some people do have acute stress or occasional stress, they don't fall into the definition of PTSD. And other people who have the contrary, the complex PTSD, which is most often associated with prolonged exposure to trauma, prolonged time in that hyper-arousal state where they feel like they need to be aware and ready to react at any time, or very often on the dissociative side of the tolerance of their coping skills mechanism. So the way the trauma develops, as I mentioned a bit about the avoidance symptoms, there are intrusive symptoms when people keep getting memories of or intrusive thoughts about it, or flashbacks, the feeling that it's happening again, because the sensory cues are all come back, and sometimes you feel like they're back to that state, to that moment in time, and that is a symptom of intrusion. And there is this issue about arousal, when people cannot sleep, when they cannot concentrate, when they cannot cope, and none of those things are useful to trigger during testimony, not for anyone. It's difficult to watch someone going through a hard time in the moment where all eyes are on them, because in the moment that the witness is testifying, they're the most important person in the courtroom. All eyes are on them. Everyone is there to listen to what they have to say. So it is on all of our best interests that they are feeling well enough to provide their evidence in the most, in the highest quality that we can try to elicit in the most efficient manner. And that, yeah, all I can say is that it's for everyone's interest. Of course, I'm going to advocate for the witness here, but the more we think about it, the more we discuss, it's clear that it is for everyone's interest. Well, I think I'm going to leave it here. And if you have any questions, you can also ask me questions in French. I will do my best to reply.
Thank you so much. And thank you to all our panelists for those incredibly great insights and from the different perspectives as well. And I think one of the things you just mentioned earlier about witnesses after they come out and after the experience afterwards. I've had time again, particularly recently in a review I've done where terrible historical sexual abuse in a particular sport, and the majority of the people that I spoke to said to me, you know, for the first time in some of this is quite historical, so 40 years ago, there was 60-year-old men talking to me about things that happened to them when they were 14, and said, for the first time in my life, I feel like someone in authority is listening and believing me. And they've carried that for so long, and that's just specifically to cold case, you know, longer cases, but which we also have here at the court, of course, where things happened a long time ago. Finally, someone's listening and believing me, and for me to tell my story, it's a therapeutic thing in itself. So we don't always have to have the assumption that they're going through and giving evidence is going to be the worst time of their life. Actually, sometimes it's a really great process for them as well. But that again varies from person to person. But yeah, so it's absolutely fantastic. I couldn't be more stoked to be here with these incredible women with your experience. Questions we've absolutely gone way over, which of course is expected. I know in my world anyway, but we could just open the floor for 10 minutes and take a few questions. I think there was a hand raised here.
Well, first, thank you so much. It was super interesting, and I really enjoyed having your different perspectives as a young lawyer. I think it's super important to start being exposed to this kind of thing, so as not to repeat the mistakes that many other people have made, and try to make the most positive impact that we can. So thank you so much. It was very interesting. And I have a question for Cecile, because she was talking about how sometimes from the defense team it's necessary to confront the act, right? But that normally it's tried, this this is tried to be made from the perspective of like trying to like confront the most like contradictory statements or something like that. And I was just wondering, how do you reconcile this with the fact that, as we said, that memories sometimes are not like well, linear, or all these things that we've mentioned. Sometimes it's normal that there are contradictory statements. So I'm just like curious of, from your experience, how to, let's say, make a contra-interrogatory on the act as such in the least re-traumatizing way, taking into account that victims' statements are not always something super coherent and precise.
Yeah, thank you. I think it also applies to every witnesses actually, because they all have trouble to remember when, where, and also mixed, and we always have this kind of issues of contradictions between a declaration that has been taken like, I don't know, 3, 4, 5 years ago, and when they come at trial and they don't remember what they said, and they have a different recollection of the events. So we are always confronted with that. And I think what we use is mostly corroboration. So with all the evidence we have in front of us, we can make arguments about what is the, when and where it happened and where was the accused. For example, for us, it's going to be all about the link with the accused, and on the specific situation of victims of sexual violence, and the fact that they can have a story that is even more how to say, like less logical and a bit all over the place, probably sometimes. I think we take that into account, and we actually don't, we won't make it a huge deal in court and then saying that, oh, you contradicted yourself on this point. But, yeah, of course, it's part of a job, we have to do it, but we also know that the judges are very aware of this situation. They are professional and they are here to assess and to, at the end of the day, they're going to decide if this contradiction is important or not. That's going to be on them to decide if this is actually not impacting at all the credibility of the person because of all the background and what she went through, or if it's actually impossible that she was here at this moment with the evidence on itself.
Thanks, Reggie. Thank you, everyone. I've got a couple of questions. Maybe I'll just skip them both. And,
Yes, please.
it's mainly, I think, for Neve and Marie Clara. So, taking on board that we can't predict how different witnesses will react and what will trigger them and what will be their vulnerabilities. So in planning investigative interviews, with the OTP has a practice, as most of you will know, of first having a psychosocial expert sit with the witness to determine A, if they're fit to be interviewed, but B, also to give them support and advice, etc., and possibly sit in. How can we best use that process to gain insight into those areas that will be particular triggers for them, or how best to plan our interview? Bearing in mind that the psychosocial expert is, is an employee of the OTP, and they're a forensic tool. They're not an independent clinical psychologist working on the victim's behalf necessarily, or obviously they'll have victims' interests at heart as well. So that's the first question. The second question is on the issue of agency. So we have a number of procedural tools that can be used to facilitate the evidence of, with the introduction of the evidence of vulnerable witnesses, so they don't have to keep repeating their stories over and over again, but maybe they don't even have to testify at all. So we can use a tool of Rule 68.3, where we can hand in the statement, which then of course takes on even greater importance that we get that right. But also even possibly 68(2)(b) in case that the witness's evidence does not go to the acts and conduct of an accused, if it's a remote perpetrator. How do we balance that against the agency of victims who might want to come and tell their stories? I mean, I would normally approach it from the legal perspective that, if I can bank a statement under 2B, why would I call a witness who might be vulnerable, might break down on the stand, who might muddy the waters, and in the process might traumatize themselves. So those are sort of two things that I was wondering if both of you perhaps, and of course, anyone else who wants to contribute.
Yes. If there's any other questions in the room, we can go with that. Let's go with that.
Yeah, it's a very important point, Anton. I certainly should have mentioned the fact that we had the luxury in the Office of the Prosecutor of having the specialized expertise of the psychosocial experts. They're not there to make a diagnosis, but they do have preliminary screening tools to see if someone gives an indication that they may be in particular experiencing PTSD. The advice that they can provide in the immediate context of how to engage with that person, how to structure the interview, where the potential flashpoints are, how to build in breaks, what their basic immediate needs are, I think is very valuable. I mean, it's very difficult to preempt and to plan in advance for the whole universe of how this can manifest itself, because you were talking about the different impact that trauma has on memory. One thing I remember being really struck by is a conversation with someone from the interpretation unit who said that they've experienced scenarios where you do a screening with a witness, you find out that they, let's say, have lived in a European country they experienced the crimes as a child, they've lived in a European country for most of their adult life, so you don't arrange for an interpreter because you think you can conduct the interview in English. But the traumatic memories were encoded in their mother tongue, and they can't retrieve them without lapsing back into their mother tongue. So something as left field as that, you're just going to have to deal with in the room. I think what is most valuable about the psychosocial assessment procedure, and that we have not always made the most use of because of the limitations of it being a judicial proceeding. A psychosocial expert and a very experienced investigator can tell you, this is what we need right now for the next 4 days in this room with this team as it's currently composed. And they can absolutely make the best of those circumstances. But it can also give you a crucial heads up as regards not just what the triggers or flashpoints might be in terms of topics of conversation or lines of questioning, but also the vulnerability factors and the resilience factors that Maria mentioned. So the immediate, medium-term and long-term support needs. So you can find out what you need to do right then and there to enable the interview to proceed. And that is the primary purpose of the assessment, it's fitness to be interviewed. And then also recommendations for the conduct of the interview or follow-up support. But we have this fundamental constraint on us by virtue of the role of the different organs and the fact that this is a judicial process, that you cannot do something that's seen as an inducement, which is absolutely valid. And it is reasonable to say, well, of course you're saying that you got medical treatment, you got financial support, you got relocated, whatever it might be. But I think we should reframe that in a trauma-informed approach, guaranteeing that it goes through the registry as the independent arbiter, so it's something that requires a lot of inter-organ cooperation, and guaranteeing that it's something that's available to any witness regardless of the calling party. It is necessary for the preservation of evidence, not just to mean that the evidence doesn't degrade and that there is as much consistency and clarity as possible between the statement and the testimony in court. But also in many cases with complex trauma, to make sure the person is still alive to testify, never mind willing to come and testify. And I think one useful way of thinking of it is, especially in relation to sexual violence. In the Rwanda tribunal, you had people who contracted HIV because they were raped during the genocide. They needed retroviral medication. They needed medical intervention and support to be alive long enough to be called as a witness to testify. Someone who is suffering from severe trauma, from PTSD, from suicidal ideation, someone who is displaced, who has no, in a domestic context, you have social workers, you have hopefully a semi-functioning health system, you have referral pathways that are built in. We don't have the luxury of any of that. We are potentially the only source of support or referrals for support that they are ever going to encounter. If we don't provide that, because of the fact that it's trauma that's driving it and it's invisible, but the manifestations of it in terms of self-harm or an inability to countenance continuing to cooperate with the judicial process, those are very, very palpable. I think we need to be more proactive, and again, this goes back to the Article 68 point. We need to be as proactive about well-being and psychological support as we would be for medical intervention or for physical protection and security risks. And the starting point of that for us, as one of the parties, is the psychosocial assessment. In terms of the procedural tools and the versus agency, I also think that's something that needs to be individualized. When you have engaged with someone, when you have explained the whole process, when you have the informed consent and the uninformed consent in the unvarnished reality of all the different ways this might play out and the different risks of exposure that will entail and different anxiety triggers that it will bring up. To a certain extent, it's for the witness to make that choice. But if you've established a good relationship with them, and if you are proactive about maintaining that relationship, then you can gauge as you go along. You might think this is someone we need to call in person. Their evidence is so relevant. It goes directly to the crimes or the individual accused. We have no choice but to call this person. For other people, if it's a flip of a coin scenario, rather than sort of making the paternalistic assumption, I think it is good to not necessarily to ask them, do you want to come in person or do you want us to use one of these other procedures? But at least to consult with the people who engage with them directly and to say, you've spent a week with this person, you've been in continuing contact with this person, what's your sense? That also relates to, have we done a support referral? Has their personal circumstances deteriorated or improved since the time that we interacted with them? If they were to make the choice again tomorrow, what would that choice be? My personal instinct would be that, with the exception of a scenario where you just introduce their statement and they don't testify at all, there can be advantages and disadvantages to some of those procedural things. Calling someone as a witness saying, you know, Mr. or Madam Witness, is this your name? Is this your statement? And then going straight to the cross-examination, in a way seems like it's shortening and streamlining the process, but in another way is just jumping straight to the bit they were most worried about. So it also means that their ability to do the narrative part and to get the opportunity to say themselves in public and be heard and respected and listened to can be limited. And they just immediately go to constrained, closed cross-examination questions about aspects of their story that are not the important ones for them. So I think it's really fact and circumstance specific. But I do think it's valuable for everyone at the planning phase both for the interviews, for the review of the statement after you've taken it, and for the selection of the trial list of witnesses, to think on an individual basis, what's every menu option we have available? And for each of these individual humans, which one of those menu options do we think is the best balance between their interests and the evidential needs of the case that we're trying to put forward? Because it's inevitable. You need to call people who ideally you would want to spare that experience, who you don't think are resilient or capable enough, who you don't think are going to have a positive, empowering, cathartic experience, because they're the only witness you have for A, B, C, D, and E facts. So yeah, long story short, it depends.
Did you want to add anything to that?
No, yeah, when you mentioned about, yeah, we never know we can never predict how people are going to react. So this is one of the things we try to do in the preparation phase, in our assessment process prior to the hearing, is to, normally we try to interview them as close as possible to the testimony, because the re-traumatization tends to come as close as possible to the moment that they know that they're going to be talking about it. So we don't do it 2 weeks before they testify. We do as close as possible to the testimony, and we try to do it after the familiarization, after they've seen the people that they're gonna examine in the courtroom, after they already either read their statement or had a preparation session with the calling party. So meaning they already had contact with the content of their testimony. So we try to, we cannot in any way interfere with what they would talk about, but we do ask, how did you feel going through that? What was your experience in recollecting this? Was there any part, is there anything that you expect to find it difficult during your experience testifying? For many people, it's not obvious that the questions will be related to their statement. They're afraid they're going to have to disclose additional things that were not there. And we try to say, listen, how did you feel in the process of reading the statement? How do you feel recollecting this? How did you feel talking about that and discussing this with the whole party? Is there anything that you expected that it will be difficult? And in this way, we try to, in this setting that is very different than the courtroom, in our safe room, comfortable, quiet, no pressure environment, we try to see how, if something is triggered there, we can expect that this might also be an issue in the courtroom. So we try to ensure as much support as possible, not only during the testimony, but the re-traumatization can happen before, during, or after the recollecting of the testimony. So we remain available to them. And of course, Nico already mentioned in our mandates, in the VWS mandate, of course, we are most obviously here discussing the trial witnesses during the hearing phase, but during the investigative phase, we do get involved in protection of witnesses. We do get involved in supporting witnesses, and not only that, after their interaction, if they are experiencing symptoms, trauma-related or else, due to their interaction with the court, they're still under our mandate. Thank you.
So just to follow on, I mean, that seems to me to be very useful information for a prosecutor to know before leaving the witness. Of course, you don't tell us that because we're an independent organ. But it seems to me, Niamh, that these are the sort of things that a PSC might want to ask the witness after, at the end of the day or at the end of the.
They do. They do.
And then that could be communicated to the people taking the statement so that they can avoid or deal with.
Often what happens is that the psychosocial expert will they'll do the pre-interview assessment before the basic security questionnaire, before the investigative interview begins. But if their recommendation is that this person would benefit from their presence in the room, they will be there. They can intervene at any stage during the questioning if that's required. They will check in with the witness, usually first thing in the morning and last thing in the evening. So maybe they discussed something during the day, they were okay in the room, they went back home and they were destroyed with nightmares all night. Or they know that a certain topic is coming today and they've come in with their anxiety at a 10, when prior to the interview beginning, it was only at a 4 or a 5. So their continued involvement throughout the interview, as well as the pre-interview assessment, is an incredibly valuable tool. And it's one of the most effective practical advantages that we have in terms of the way the Office of the Prosecutor implements the court-wide obligations under 68(1). The only caveat to that in terms of a trauma-informed approach is when we know in advance that someone is a victim of sexual or gender-based crimes, that someone is still a child, in some cases because of the circumstances of what they're going to discuss, or they may be an adult now, but they were a child at the time, we don't have the capacity to have a psychosocial expert involved in every single interview, which means that there are potentially situations that you could encounter where someone, you only realize they fall into that category, either severely traumatized or a victim of sexual violence, once the interview has already commenced. And in that case, there have been circumstances where they've suspended the interview and asked for a psychosocial expert to be made available. That may not always be possible, but I think thankfully we've reached a point where it's pretty universally accepted internally as best practice. And again, it's exactly what I said in my initial remarks. It's not something we're doing as a kindness. It's immediately helpful to every member of the interview team and to all of our follow-up interactions with the witness and the choices we make about the trial. So I can't recommend it either.
That's such a great point. There's just, I know we've gone over time, but there's just one interesting question from online. There's a few others which I won't be able to get to, but it's for you. I think Cecile will be a good one for you to respond to. It says, because OGP and defence investigate separately, victims can be interviewed first by one party and then re-interviewed by another. Could it be possible at the stage of investigations to interview victims only once?
If your victim has been met by the prosecution, then it's a bit tricky, because sometimes if they are a witness for the prosecution, then we cannot go see them without asking the consent and informing the prosecution, and they have the choice of the prosecution being present or not. In practice, I think we are more interested in meeting insider witnesses rather than victims, because we have the statement, we don't need to go see them again. So we tend to avoid this. If we need to, probably a solution can be the prosecution present, because there's someone they know. But from the outset, interviewing a victim, both prosecution and defense together, seems impossible to know, because the prosecution is investigating years before the defense is even appointed to a team.
Yeah, that's true. Yeah, but thank you for that. I think we better call it quits now, because it's 12:15 already. But just without further ado, I'd like to thank you all for coming today. Thank you for being here today. Thank you for everyone online, and particularly thank you to our panelists. So thanks for being here today.
Thank you very much.
Thank you, Dominic, as well, for doing all the running around.